welcome to today's episode of Business is More Exciting Than Any Game. Today's episode is going to be a tax law episode. The question we're going to talk about today is this: are settlement proceeds in litigation taxable or non-taxable? When are they taxable? When are they non-taxable? Particularly with respect to the issue of emotional distress. And to talk about this episode, I'm going to focus on a case that came out earlier this year in the U.S. Tax Court called Doyle versus Commissioner. The case was, the opinion was written by Judge Holmes, who writes great, very interesting opinions. If you have any interest in tax law, you love reading Judge Holmes' opinions. This case involved a man named Doyle, who, after he had graduated from university, went to work originally for Intel, and then after working there for a number of years, moved over to a startup company in Silicon Valley where he worked for the next 22 years. The company did well. It went public. I'm sure he made a lot of money doing a lot of great work at the company. Over the course of time, the opinion said that he got or obtained 9 or 10 patents. These were dealing with touchscreen LCD technology like you would find on a smartphone or an iPhone or a tablet today. After he left the startup company, after working there for all these years, he started his own consulting company. He did that for a while, and then he went to work as an employee of another company that was in the high-tech area. He worked there for a number of years and did well again. But he got concerned about some issues there at the company. He went to talk to the CEO after talking to his attorney about the problems, and his attorney had advised him either you need to leave immediately or you need to raise these issues with the CEO. So he raised the issues with the CEO, and a week later he was fired. So Mr. Doyle filed a lawsuit. He alleged breach of contract, unlawful discharge, a number of other things. And the case was quickly settled, and he received, pursuant to a settlement agreement, $350,000 in lost wages or unpaid wages, and he received $250,000 for emotional distress. Now, at the trial, the facts showed that Mr. Doyle had suffered a number of physical issues arising out of this emotional distress. He had insomnia, he had back problems, stomach problems, difficulty digesting food. All of this came out in court, and it was not really disputed that these were facts. The issue was whether or not this $250,000 that Mr. Doyle got in the settlement for emotional distress was taxable or non-taxable. And it all boils down to a particular section of the Internal Revenue Code, Section 104A of the Internal Revenue Code. The general rule under the Internal Revenue Code for taxability of gross income is actually in Section 61, which makes the general rule that basically gross income from any source is taxable. In order for it not to be taxable, you have to find an exception. Now, one of the exceptions to inclusion of all income and the taxability of all income is found in this section 104A. 104A exempts out from taxability damages either in settlement or at trial that are received for physical injuries or physical sickness. Now, in this case, Mr. Doyle at trial showed, and without any dispute, that he had physical symptoms or physical issues that arose from his emotional distress. The problem was his complaint, as well as the settlement agreement. Mainly the settlement agreement was the problem. It provided that Mr. Doyle received $250,000 for emotional distress. Section 104A makes clear that the non-taxability for damages for physical injuries or physical sickness do not apply to emotional distress. In fact, it says expressly that damages for emotional distress don't receive the exception from taxability. In other words, damages for emotional distress are taxable. Case law even makes clear that it happens commonly that emotional distress leads to physical injuries or physical sickness, but those physical injuries or sickness, such as insomnia, headaches, whatever, the same kinds of things that Mr. Doyle had, if they arise from emotional distress, they're not the damages for that emotional distress, even though it leads to these physical injuries, the damages are not non-taxable. In other words, they are taxable. Now, what could have been done, or what could be done in the future if you have an issue with your small business, or you as a person, as an individual, you have a case in which you allege some damages for a breach of contract, or for a tort, or for something, for negligence, and you allege some emotional distress damages and some physical damages, that type of thing. Well, there are a couple of things that you might want to consider by just having looked at this particular case. One is, you might want to allege in your complaint not only the economic damages from a breach of contract or whatever that might be as the main source of the complaint, but you also, and you might want to allege the emotional distress, but you might want to allege separately that you have physical injuries and damages from physical injuries or physical sickness, separate and apart from the emotional distress. In fact, if you can prove and you can show that the emotional distress actually arises from the physical injuries and the physical sickness, rather than the physical injuries and the physical sickness arising from the emotional distress, you'll be a lot better off. That's under Section 104A, if you can show that the damages are really for the physical injuries, not for the emotional distress, and that the emotional distress actually was a result of the physical injuries, you'll be a lot better off. Also, in your settlement agreement, you want to make clear that if you get a payment, maybe some of it may be for emotional distress. It may be the case that you do get some damages for that, but you want to make clear that some of the damages that you receive in your settlement agreement are specifically for physical injuries or physical sickness, not for emotional distress. That's important because in this case, Mr. Doyle got in the settlement agreement, it said $250,000 for, it was a general release for all claims, including emotional distress, and I think it had an allocation only to emotional distress for the $250,000. That under Section 104A, that was enough to cause him a problem that couldn't be overcome. So going back to what one can do in the future, if this comes up, is talk to your tax advisor early. You may want to allege in your complaint before you even get to the point of settlement that you have damages for physical injury, physical sickness, separate and apart from emotional distress. If you can prove that, again, as I said, that the emotional distress is the result of the physical injuries rather than vice versa, that would be preferable. Again, you have to be able to prove that. And then lastly, make sure in your settlement agreement that you have a separate allocation for physical sickness or physical injuries that is separate and apart from damages for emotional distress. I hope that helps. That's it for today. Talk to you next time.